Hi, my name's Sasha Moore, and I'm delighted to be moderating today's Legal Update, an initiative from UniSearch, Australia's leading and most established provider of expert opinion services. This program has been created to provide bite-sized updates on various matter areas to help keep the profession informed about topical developments, legislative updates, and changes in the respective fields. Welcome, and thank you for joining us. In today's discussion, we're going to draw upon the insights from one of UniSearch's esteemed experts, Eliza Northrop, an international environmental lawyer and academic specialising in international environmental law, climate law, and policy, as well as ocean governance. Eliza has been admitted to practice law in both the Supreme Court of South Australia and the New York Bar, and publishes widely on international law and global environmental governance, particularly in relation to oceans, climate action, and plastic pollutions. She also contributes to international assessments and expert groups, including the Third World Ocean Assessment and the UN Ocean Decade for Ocean Sustainability Programs. So in this discussion, we're going to touch on the new High Seas Biodiversity Treaty, why this is significant, and the core mechanisms of the treaty. We're also going to look into how the treaty interacts with existing international frameworks and processes, as well as the practical or strategic implications for us in Australia. The broader insights will also be covered in terms of what should legal practitioners take away from this development. Without further ado, welcome, Eliza.
Thank you, Sasha.
We're also joined here today by UniSearch's Business Development Manager, Christopher Aaron Yong. Christopher will provide additional context, including commentary on how lawyers can maximise an expert in engagement in such matters and what he's really noticing from a bird's eye view. Welcome, Christopher.
Thank you, Sasha.
Okay, let's get started. So, Eliza, I'm going to put you in the hot seat. Let's start from the beginning. Could you give us a bit of an explanation of what the new High Seas Biodiversity Treaty is and why it's significant?
Certainly, Sasha. The new High Seas Biodiversity Treaty, also commonly referred to or shortened to the BB&J Agreement. Its actual full title, for accuracy, is the Agreement under the UN Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction, which is quite a mouthful, which is why we keep shortening it to either the BB&J Agreement, which is where you might see that referred to by a lot of commentators, or the High Seas Biodiversity Treaty. So I just wanted to be really clear that that's what we're talking about. So this is the third implementing agreement under the UN Convention on the Law of the Sea. And I think most critically or significantly, it is the first legally binding instrument in terms of being binding under international law to specifically address the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction. That is, areas of the ocean that fall beyond the 200 nautical mile exclusive economic zone, EEZ zone, otherwise known as the ABNJ, lots of acronyms. And this area covers the sort of the water column as well as the seabed, which under UNCLOS is referred to the area. So really significant new legal development in the field of international environmental law. Practically speaking, I suppose, or what we mean when we're talking about the high seas. As I said, that is the area of the ocean that extends beyond that area that falls under national jurisdiction of states. And that represents more than about 60% of the global ocean surface, so really significant. It also, in terms of depth or volume of water, is close to 95% of the total volume of the ocean. So this is a really massive area in terms of global area, and is some of the sort of least known. We have the least information about the biodiversity in this space, as well as the least protected areas on Earth. However, we do know that the high seas provides essential services for the world's ecosystem. It's critical in terms of marine mammals, fish stocks, and is also a really important area of marine genetic resources, which, as we know, are really critical in terms of new technologies and pharmaceutical, among many other uses. However, despite its size and its significant to sort of critical economic and ecosystem services, less than 1% of the high seas is currently subject to any form of spatial protection, marine protected areas. And this is one of the key governance gaps that the BB&J agreement, the High Seas agreement, has been designed to close. Now, why I suppose this is most topical is after nearly 2 decades of negotiation for this new treaty under international law, it entered into force earlier this year on the 17th of January. This happened 120 days after the 60th instrument of ratification was deposited, which happened in September last year. As of today, we've got 88 parties, so 88 countries have deposited their instrument of ratification with the UN, but we have a broader 145 signatories, so parties that have indicated their intention to deposit their instrument of ratification and become a party to the treaty. And they're just going through their domestic ratification processes now, which for many countries, Australia included, takes a significant amount of time. So we are expecting that number of parties to grow quite significantly over the course of this year. And I think having that 145 signatories really indicates the broad support that this new treaty receives globally across all regions, all economies, and all ocean basins. So as I said, this has been sort of a nearly 2-decade-long negotiation and fight by many countries to really put in place a legal framework that manages biodiversity and the sustainable use of the resources in the high seas in an integrated way. We've had a number of sectoral bodies, obviously the International Seabed Authority, the ISA, that governs mining of the seabed, the area, as well as a really comprehensive regional fisheries management architecture that manages fish stocks and sustainable levels to support our fishing industry, as well as the IMO for shipping, but no sort of cross-sectoral or cross-cutting regime to maintain or protect the biodiversity on which so many of these sectoral industries rely on. The treaty was also, in terms of its significance, I suppose, concluded in parallel with the Kunming-Montreal Global Biodiversity Framework under the Convention on Biological Diversity, which established the 30 by 30 target. This global target that, for many reasons, it was really important that we protect 30% of our terrestrial or marine ecosystems by 2030. And so the BB&J agreement is a really key pillar of how we're going to achieve that 30 by 30 target without increasing protected areas within the high seas, this globally really significant area. Mathematically, it's going to be very difficult to reach that 30% target, and is really crucial for that integrated ecosystem protection and management. Bringing that down, I suppose, in terms of Australia, within Australia's EEZ, more than half of Australia's marine asset, maritime jurisdiction within that EEZ is protected through our marine parks network, including sort of just over 2 million square kilometres that falls within a highly protected zone. So Australia is really, I suppose, a world leader in terms of the volume of its marine estate that is under some level of protection or sustainable management. But obviously, what happens in the high seas, particularly in those high sea pockets around Australia, Australia and New Zealand, and into the Pacific, has a direct impact on the health of Australia's oceans, as well as Australia's marine industries that depend on the health of those ecosystems, tourism and fisheries being two really notable ones. And that's true for all coastal states, but particularly acute for those that have really large and significant marine estates and blue economies. And certainly Australia and within our region, the Pacific, that's very true. So I suppose to pull all that together in terms of significance globally as well as nationally, this is the first time we've had legal architecture that can designate marine protected areas in the high seas, as well as, and I can speak to this a little bit more, but the Act also brings into force a really comprehensive and quite stringent environmental impact assessment for activities taking place in the high seas. And lastly, and not least, puts in place a benefit sharing agreement for the sustainable use of marine genetic resources from the high seas.
Well, that is quite the development. If we now just break it down, coming from the macro to just more of the mechanisms, could you just provide a really brief overview of the core objectives and the mechanisms of the treaty?
Absolutely. So the treaty itself is quite a large one. It's often being described as about 4 treaties in one. And that's because it covers off on 4 key pillars. I mentioned 3 of them earlier. Pillar 2 or part 2 of the agreement really deals with this concept of equitable benefit sharing of the non-monetary and monetary benefits associated with the use of marine genetic resources in the high seas. Second part is that creation or the ability to create area-based management or areas of protection, MPAs, within the high seas. Then we've got a part within the agreement that creates this environmental impact assessment, EIA regime that I mentioned. And lastly, which is really critical for most developing countries, in particular small island developing states, there is a very significant part of the agreement that addresses capacity building and the transfer of marine technology, because obviously the high seas is an area which is there for the good of all humankind. It's area of the global commons. So making sure that everyone can access and benefit equally from the high seas is really important. So that's a very quick snapshot, and I'm happy to go through what each of those means in a little bit more detail.
Sounds good. So would you like to go into that micro detail, that next layer through?
Absolutely. So I'm just going to talk probably mostly about the marine genetic resources, the area around the creation of high seas, MPAs, and the EIAs, because I think that's probably most relevant for an Australian audience at this point in time, at least. So the provisions around the creation of an equitable benefit sharing arrangement for marine genetic resources was certainly one of the most contentious parts of the negotiation. Essentially, because some parties believed that those MGRs belong to everyone, like deep sea, seabed minerals do, or, does that fall into sort of the freedom of the high seas and everyone can take what they want? The agreement doesn't quite say that MGRs belong to everyone, but it does create a regime where that picks up on the spirit of that idea, particularly when we look at the benefit sharing. And again, this concept of marine genetic resources is commercially very important, which is why it's important to so many parties that there is a system in place where the benefits of the use of marine genetic resources by private companies for commercial purposes, that there is a mechanism in place to share some of those both non-monetary and those monetary benefits. And so when we're talking about the commercial uses of MGR, that's, as I said, pharmaceuticals, enzymes for industrial use, cosmetic ingredients is really important, as well as obviously, for use in new and emerging technologies as well. So commercially a very critical area and area for expansion in terms of MGRs in the high seas. And the agreement essentially creates a regime where ultimately, once it's fully developed, there will be unique batch identifiers that can be associated with genetic resources that have been found and identified and used from the high seas that will enable non-monetary benefits in terms of ocean open access to samples, data, research results to be shared, broadly, as well as and most critically a monetary benefits sharing scheme where a portion of the commercial benefit that is derived from the use of those high seas marine genetic resources actually flows into the agreement's financial mechanism or financial fund that can then be deployed to support developing countries in a variety of ways. So a really important development in access and how we use some of the resources in our high seas there. The second part, which is hopefully a little bit more self-explanatory, is the ability to create these high seas MPAs or areas of protection. And I should say this is not necessarily, the agreement doesn't require that these are automatically no-take zones. They can allow for sustainable use, but essentially it is creating that legal framework where we can designate areas of the high seas that are incredibly ecologically important and put that under the appropriate level of protection and mirror the system that most countries have in place for protected areas within their national EEZs. Any party can propose these areas of protection. And they bind every party to the agreement. So a really important aspect, as I said, for achieving some of those global protection goals that I mentioned. Last but not least is a little bit more detail around the EIA system that is now created under the treaty and is a much more comprehensive and strict regime than what was previously provided under UNCLOS in terms of activities undertaken in the high seas in the area beyond national jurisdiction. It essentially establishes a two-stage threshold, which, as I said, is currently stricter than what we have, that involves now a screening trigger. So for any activity that may have more than a minor or transitory effect on the marine environment in the high seas, or where the effects of that activity are unknown or poorly understood, there is the need to undertake an initial screening. So a much lower threshold than we currently have under UNCLOS for activities. Once that screening is undertaken, there is the potential trigger for a full environmental impact assessment if there's reasonable grounds for believing that the activity may cause substantial pollution or significant and harmful changes to the marine environment. So the scope of impacts is really broad. It includes sort of economic, social, cultural, human health impacts, as well as cumulative impacts. And then there's also increased transparency requirements for those EIA reports and EIA processes. They all have to be lodged with a central, it's called a clearinghouse mechanism. And that will be held centrally under the BBNJ treaty sort of institutional architecture. And then, as with most EIAs, there is a monitoring, review, and sort of adaptive management requirement that flows out of that once an EIA has been done and an activity moves forward. So that's a reasonably sort of high level, but hopefully useful deep dive into some of those three key parts.
Amazing, thank you. Well, before we look at what the practical implications are for Australia, I'd love just to get a very brief synopsis on how the treaty interacts with existing international frameworks and processes.
Absolutely. So, as I said, it sits within an existing treaty framework, the UN Convention on Law of the Sea. It's one of the third implementing agreements under that treaty, which is often referred to as a bit of the Constitution of the Ocean. But the high seas is a complex place, and I think this was always forefront of negotiations to be able to get agreement on these substantive provisions is a critical provision under the BB&J agreement that the agreement itself must be interpreted and applied in a manner that does not undermine relevant legal instruments and frameworks and relevant global, regional, sub-regional, and sectoral bodies. So essentially, it is an agreement that slots into an existing institutional and legal architecture. It is not creating anything that duplicates or overrides the existing frameworks and legal instruments that are in place, which is very important. And I think what that means in practice is still being worked through. So at the start, I said that the agreement has just entered into force. We've just concluded the third and final preparatory commission, which is the negotiation process that happens once a treaty has been adopted, but before the first meeting of the Conference of the Parties. And this is a really important process where we start working through the details of what has been agreed in the treaty itself and sort of operationalizing that ahead of the first conference of the parties, which is going to happen in January next year, when not all, but many critical decisions are going to be taken around the modalities and operating provisions of the treaty. So this provision in terms of interaction with other international frameworks and processes is a really critical provision. How it actually is applied in practice remains to be seen, and will probably be seen in a number of different circumstances or examples over the next few years. I will say, I think in terms of the interpretation of this provision, I think the mainstream view is a sort of a functional reading in that the agreement is complementary rather than subordinate to other legal instruments, and the intent is that the BB&J provisions are meant to be read so that they don't sort of erode the operational effectiveness of existing instruments and existing frameworks, so that it is complementary, doesn't override, but is also not subordinate. And I think a bit of a practical example for anyone that works in a fisheries-related industry, when we look at the relationship between the BB&J agreement and the regional fisheries management organisations and the RFMO framework, which is really critical in terms of global fisheries management. I think that the non-undermining clause under the BB&J agreement really supports a complementary role for the BB&J COP alongside the RFMOs in terms of implementing area-based management tools within RFMO management areas. I don't think it comes in over the top, or that we're going to see a regime where protected areas are not cognizant of existing agreement and management practices, particularly when we're looking at the fisheries industry there. So I think, but it will be important to look at some of the early decisions coming out of the Conference of the Parties starting next year as to exactly how this is going to work in practice.
Okay, great. Thank you. So let's then dive into what the practical and or strategic implications are for Australia.
So Australia was one of the first signatories to the BB&J agreement back in 2023, and has played a leadership role. Australia is one of the two co-chairs alongside Belize of this preparatory commission that's operated over the last couple of years, as I mentioned. So Australia has been actively engaged in the BB&J agreement, not just the negotiation, but now sort of moving into that implementation phase, which I think is also important to signal about the importance that Australia and the Australian government places on the BB&J agreement and its role in high seas management. most critically, so Australia has been going through its ratification process since it signed in 2023, which is a lengthy process. Australia has not yet ratified, but I think we're expecting that really shortly, because on the 31st of March this year, just last month, Australia passed the High Seas Biodiversity Act. And this is sort of the key step in then enabling Australia to deposit its instrument of ratification and formally become a party, and therefore be able to be part of that decision-making process at the Conference of the Parties next year. So really critical in terms of Australia's ability to actively participate as a party and shape the implementation and operationalisation of the treaty itself moving forward. The Act also, for domestic purposes, implements those three substantive pillars of the treaty that I talked through earlier: marine genetic resources, high seas MPAs, and really critically the environmental impact assessment and what that means for Australia. It also creates a ministerial authorisation and notification regime that will affect any Australian entities operating on the high seas, but also any Australian entities that are operating within Australia's jurisdiction, Australia's exclusive economic zone, but whose activities could significantly affect the ABNG, the high seas marine environment, and creates a reasonably comprehensive penalty framework of up to sort of 7 years imprisonment for infringement of that as well. So that's sort of a quite high level summary of that act. The two things that I just want to point out in particular is the importance, I suppose, of this piece of legislation in now creating a standalone environmental impact assessment regime that is directly tied to an international treaty, the BBNJ agreement in this respect, but sits alongside Australia's existing legislation, the EPBC Act. So this is quite a significant structural development in terms of Australian environmental law. It didn't amend the EPBC Act to bring ABNJ activities within existing matters of national environmental significance, but the Act creates sort of a parallel and purpose-built regime under that new Act. And I think we will, it is very early days, but this will be an area that we really have to carefully unpack in terms of its strategic and operational consequences. But I do think, early awareness around anyone sort of advising entities that operate in Australia's marine environment, that there is now both the EPBC Act and the EIA provisions that are applicable under that for anything within a national jurisdiction, but also being aware of the EIA regime established under this new Act, where those marine activities, even if they take place within Australia's jurisdiction, may have an impact on the ABNJ adjacent to Australia's EEZ. So I think that's a really important and this could sort of, I suppose, trigger any of the activities in terms of petroleum operations, deep sea cables, large scale marine infrastructure, aquaculture at scale, and if it's far enough out, or any sort of fisheries related activities where there is sort of a credible impact that could happen on the ABNJ, particularly cumulative impact. So I think one that warrants further consideration. As I said, we're in the early days. It has just passed, but important to watch there.
Indeed. If we just drill down a little further in terms of the insights that legal practitioners should take away from this development, could you just unpack that next layer?
Yep, absolutely. So I think back to this EIA point, obviously there is a need to really understand the detailed provisions and how they will operate and affect different entities and activities in Australian waters that may have that impact on the ABNJ, and understanding that regime under the new Act. But I think more broadly, perhaps seeing that this comprehensive EIA framework that has been established under the BBNJ agreement will probably start to emerge more and more as global best practice, or creating a global floor, I suppose, in terms of EIA. And so that's relevant in terms of understanding EIA obligations and triggers for an Australian audience, but also globally, and for any Australian entity that operates globally is where we're probably going to see that become the standard. So I think that's one thing. The second that I wanted to flag, I think, is really coming back to this concept of the clearinghouse mechanism that I mentioned as being the central information repository for the agreement, both from an EIA perspective, from an MGR perspective. Sort of this is the central global information source. And I think it's easy to see that as largely procedural, administrative, but I do think it represents a bit of a structural change to the information environment for the ABNJ. I mentioned at the very start, the high seas, the ABNJ, area beyond national jurisdiction, is one of the areas where we really know the least about some of these ecosystems, some of these organisms that are out there. There's a lot of information, but there is a lot to go given its size and its significance. So I think the BBNJ agreement triggers a bit of a step change in the availability of that information. I think for the first time through this mechanism, you'll have governments, civil society, investors, other states, really with a centralized, publicly accessible records of activities that are occurring in the high seas or could impact the high seas, particularly through the EIAs, which are all required to be submitted to the clearinghouse mechanism, including potentially, as I mentioned, those EIAs that may be conducted based on activities within national jurisdiction, but with those impacts on the high seas, that will also potentially be required to be communicated and stored within the clearinghouse mechanism, along with sort of monitoring data around high seas MPAs, MPA management plans. So we're again starting to see a much more centralized information source, where information that potentially might have been more national in nature will also be required to be communicated and held under that clearinghouse mechanism, giving potentially additional oversight on some of this, or opening up at least commentary from other governments and from civil society. So I think just something from a transparency perspective to be aware of, again, for anyone that's operating or undertaking activities. Lastly, I think just also being aware of the fact that we will start to see more and more high seas MPAs be discussed and brought forward. There's a group of countries, sort of first mover countries, Australia participates in that group, that are really trying to work through and advocate for particular pockets of the high seas to be among the first that are recognised under this new regime and afforded the appropriate level of protection. Sort of close to home, one of those areas is the Lord Howe South Tasman Sea rise. So, for those that are operating in anything that is adjacent to that, or interested in following along for an area of incredible biodiversity importance. It's a really important breeding ground, a migration corridor for a really broad range of species, humpback and southern right whales among those. That's a really interesting one to just see whether that progresses in terms of being put up for protection under the BBNJ agreement. That's close to Australia. And then, of course, just in terms of what's going to happen next, I think I've mentioned this already, but we've got the first conference of the parties where all the critical decisions about operationalizing these provisions that I've talked through will start to be made. That's going to take place from the 11th of January next year in New York. And some of the main focus areas will be establishing the financial mechanism. So the fund that is going to be potentially receiving the monetary benefits from MGR, exploration and use in the high seas, establishing the scientific and technical body, which is going to be setting the standards and providing a lot more details around these EIA provisions, and the creation and management of MPAs. And these what are some of the first MPA proposals globally going to be as well? I think will be really interesting to watch. And then more broadly, obviously, actual implementation of this new High Seas Biodiversity Act in Australia, which, as I said, was a critical step in enabling Australia to become a party to the treaty, but also is a comprehensive new piece of legislation within Australia's environmental framework in its own right. So lots going on, lots to watch.
Indeed. Thank you so much. Christopher, I'm going to throw to you now, just coming from a bird's eye view with visibility across multiple related matters. What are your observations in this space?
Thanks, Sasha, and thank you for your insights, Eliza. What I'm seeing on the ground when speaking with our international and national law firm clients is a growing appreciation for the fact that developments in international environmental law don't operate in a vacuum. They really have real-world implications for domestic practice and for the clients that they serve. And I'm seeing this across the plastic sector, climate processes, biodiversity frameworks, and broader sustainability governance. As we heard from Eliza, while recent developments related to the treaty don't create immediate obligations for Australian firms yet, I'm noticing that more proactive practices, in particular large international firms or boutique firms who specialize in international law, ESG, or advisory work, they're really starting to think decades in advance and are positioning themselves for the flow-on impacts. They're really looking at this through a few different lenses. As Eliza said, they're considering the strategic and operational implications across their legal and non-legal practice groups. From a compliance perspective, they're thinking about their clients and where they're domiciled, whether in Australia or internationally. And they're also looking at assessing their current and future state approaches to impact assessments. Ultimately, this kind of illustrates at a high level how these global developments really do cascade down and impact regulatory settings, domestic industries, and contexts. So to summarize, whether we're looking at plastics, circular economy frameworks, biodiversity protection, or high seas treaties, these firms are increasingly recognizing these policy developments and that this emerging legal architecture really do have material, tangible implications for them and the clients that they serve. Internally within UniSearch, we're also seeing an uptick in demand for world-leading independent experts. These experts do have deep specialization and capability in sustainability, climate governance, and environmental risk. And senior lawyers are actively kind of seeking these experts to close their knowledge gaps, bring their team along that journey, and to make sure that they're all ready for these emerging market shifts that are starting to take shape both in the legal and consulting context, but both internationally and domestically.
It certainly is a watch this space moment in a very multidimensional capacity. Thank you so much for your tremendous insights, Eliza. We appreciate your holistic assessment on the new High Seas Biodiversity Treaty, its strategic implications, and the broader insights for practitioner. And thank you, Christopher, as always, for your commentary on this evolving legal space. And for those who have tuned in today, we hope you found today's session insightful. If you'd like to reach out to UniSearch to discuss a matter, you can email Christopher at c.yong@unisearch.com.au. Until next time, goodbye.